For any victim of an accident in Louisiana or the New Orleans area, you really need to understand that come January 1, 2026, the rules have changed in a major way. Specifically, as the law sits in 2025, we in Louisiana have a process called comparative fault, where when an accident occurs, you have to look at everybody who's involved and compare their fault. See what you, as the victim, did you contribute to the accident at all? Did you have any responsibility, no matter how slight or how large? The other drivers, so if you have multiple vehicles, you look at everybody and what they did, and you assign fault to each particular operator of a vehicle to determine what fault they may have. Under our current law, 2025 and prior, you have a right to recover the percentage of fault for any other person. So if I'm in an accident in 2025 or before, and let's say I'm 50% at fault, I still have the right under Louisiana law to collect 50% of my damages. So if the claim is valued, just use a random number for ease of math, at $10,000, under that scenario, I still have a right to collect $5,000 in my claim, because half of it was my responsibility, half of it was somebody else's. I get to collect the portion that the other person, basically, you're responsible for your portion of the crash, no matter how big or small. Come January 1, 2026, Louisiana is moving to what's called modified comparative fault. Under this new modified comparative fault rule, if you're the victim of a crash and it's determined that you are 51% or more responsible for the crash, then you get nothing, zero. So under the current law, if I'm 51% at fault, I still get to collect 49% of my damages. So let's say I have a brain injury and I need life care, and the person who caused the brain injury is a commercial trucker who has $10 million of insurance. Under that scenario, certainly the ability to collect 49% of my claim could go a long way to help provide for me and my brain injury and my needs moving forward. Well, as of January 1, 2026, under that scenario, you're sitting there with a brain injury. If they determine you're 51% or more at fault, you get nothing. So you're left to hold the bag, even though somebody else under that scenario was nearly 50% at fault for the injuries that you've suffered. So big day in Louisiana injury law come January 1, 2026, with the conversion to modified comparative fault from a pure comparative fault standpoint. So it's very important that after a crash, you have somebody who's advocating on your behalf and looking at those facts and doing their best to establish that even if you do have some responsibility, you have some fault for the crash, that fault does not exceed 51%, or meet or exceed, rather, 51% at fault. So you still have the right to collect something for your injuries and your pain and suffering. As a result of the change in the law, what's it going to change, practically speaking, on a day-to-day basis? Quite frankly, I think it's going to result initially in increased litigation and delay in people's claims. So from the insurance company's perspective, they understand that this law is going into effect, and if there are facts that, in their opinion, establish that the claimant, had some fault in this matter, and they believe in their heart of hearts that they may be able to push the needle ever so slightly beyond 50% and establish that that person is 51% at fault or more, resulting in a zero payout to them, well, they're going to fight that case to the end because it's, quite frankly, to their advantage if they're able to just move that needle ever so slightly. And I also think it's going to result in denial of access to legal representation from some. I mean, obviously, if somebody comes to me and the facts indicate that they may have a good portion of the fault and it's teetering on that, 50, 51%, it may be a case that in ordinary circumstances under old times, yeah, okay. The example I gave, the brain injury case, somebody is grievously injured. There's your insurance on the other side that can still provide a good, foundation to be able to help take care of them moving forward. Under the current law, I would take that case. Under the proposed new law, which goes into effect January 1, 2026, I may have to look that potential client in the eyes and say, I'm sorry, there's nothing I can do for you as a result of the law, because if we move forward, prosecute this claim at great expense, there's a good chance if you're found 51% or more, then nobody gets anything. And all of those expenses and everything. So it's going to, I think, deny certain people access to justice as a result of this change in the law. And I'm sure the defense bar, the insurance side, is going to push this issue on any claim that they can, because they know, hey, all we have to do is move that needle ever so slightly in our favor and the claimant gets nothing. If you've been in a crash in the New Orleans area and you have questions about your claim, there may be some indication that you might have some portion of fault for the crash, feel free to give our office a call. I'll be happy to review the facts of your particular case and give you my God's honest opinion, whether that happened before, the change in the law, and certainly after January 1, 2026. We'll do everything that we can to help you in connection with your claim.